Hello, apologies, some technical problems there. On behalf of my colleagues at the School of Law, I would like to welcome the Chief Justice back to NUI Galway. As Lee mentioned, it's almost 2 years ago to the day that the Supreme Court sat in the Aula Maxima here at NUI Galway. And that was the first time that the Supreme Court sat outside of a courthouse since it returned to the four courts in 1932, and the first time that the Supreme Court had sat in Galway. I'm also delighted to take this opportunity to congratulate the NUI Galway Law Society on its celebrations for its 100th anniversary. Those Supreme Court sittings in Galway were really the initiative of the Chief Justice, and really a hallmark of the Chief Justice term as Chief Justice has been the outreach work that he has done very successfully to seek greater engagement with the wider community in terms of the work of the Supreme Court. That outreach work has been very impactful in allowing students and the wider community gain a real insight into how our legal system works. The Student Law Society here at NUI Galway has a long and proud history. Many of our prestigious alumni have been members of the Law Society while studying here at NUI Galway. The Law Society fulfills a very important role in the legal education of our students. The Society provides valuable opportunities such as this to enrich the college life of our students, both through social and educational events. Integrating into university life, particularly this year in the midst of a pandemic, is a particular challenge for first-year students, and the supportive environment which is created by the Law Society helps students to meet friends, build their networks, and to adjust to university life. From a social perspective, the Society has, for many decades, facilitated students in connecting with each other outside of the lecture hall and the library. In particular, the Student Law Society has excelled in the organisation of fantastic social events, such as the annual Law Ball, and through other social events throughout the year, which allow students and lecturers and the wider community come together, the wider legal community in Galway. The Society, throughout its 100-year history, has really provided excellent opportunities for students to meet a range of legal academics, jurists, legal professionals, and other employers, and really to open their minds to new ideas and to potential careers that are open to them once they complete their studies. The range of employment events arranged with national, regional, and local firms has been very impressive over the years. Those opportunities from the students' perspective are very important. They're able to connect with other students and to build their networks, and that is very formative and extremely beneficial for them. From a pedagogical perspective, the Student Law Society has and continues to play an important role in augmenting the intellectual and educational experience of law students. In particular, I'd like to commend the Student Law Society for the fantastic work it's done over the past number of years on mooting and in supporting students to develop their mooting skills. Every year, the Law Society organises 2 internal moot court competitions, the Tom O'Malley Moot Court Competition and the Novice Moot Court Competition, which is specifically for first-year students, a very encouraging event to encourage students to speak in public and to develop those skills around mooting. These opportunities provided by the Law Society really are very valuable. The opportunity to come together in events like this are very valuable. And I think going forward, I think we'll have a newfound appreciation for having events where we're able to come together and meet in person. On behalf of myself and my colleagues, I wish the Law Society a happy 100th birthday and commend them on the excellent programme of events that they've organised this week. I'm now going to hand you over to the Chief Justice for really what is going to be a very interesting talk on access to justice. Thank you.
Thank you both very much for your kind introductions. It's funny to be back in one sense in NUIG. Almost at the very beginning of my time as Chief Justice, I was invited to give a lecture on reform of the courts. And then, as the auditor mentioned, just 2 years ago, the Supreme Court was in NUIG as the head of the Law Department has made clear, for the first time the Supreme Court had sat outside a courtroom since it returned to the four courts in 1932. And I'm delighted to be back here again today, though my only regret is that I'm not there in the fuller sense of the word when I'm told the weather is equally as good down in Galway as it is in Dublin. Before addressing the topic of the evening, I might recall something I said at that lecture some 3.5 years ago in the Aula Max. I made the point that the first time I'd ever been in NUI Galway was what's now very close to 50 years ago, when as a young student debater I was a member of a King's Inns team debating in the first round of the Irish Times competition. And I did recall that the final of that Irish Times in 1973, there were 12 people qualified for the final, as is usual. 5 of them ended up as judges and a 6th as the Director of Public Prosecutions. And indeed, 3 of the judges ended up on the Supreme Court. So it may not have seemed like a likely event when we were all as young students down in NUIG almost 50 years ago, but there is hope for everyone, I suppose, in the future. But the reform of the courts on which I spoke on that occasion has a close connection, I think, with the topic that I wish to address tonight. Shortly after my appointment as Chief Justice in 2017, I made a statement at the beginning of the new legal year, and in that statement I made the point that there was little advantage in having good laws and fair and competent judges to apply them if people didn't have the opportunity to access the justice system in a reasonable way. And I also suggested that there was no single solution to that problem, or no magic bullet, but that a range of different measures were required in order to address the problem. And I want to briefly return to what I might call a progress report on that theme, and comment on what I think has been significant, if somewhat slow, progress in that regard. But I also want to comment on what I think is an even more, or has been, at least in the last year, an even more fundamental challenge to access to justice, which we in the courts have had to face. Whatever may be the scale of the problem of which prevent people from being able in ordinary times to access justice, whether it's financial or otherwise, the challenges which we have had to face in the last year was in ensuring that there was a court there to access. How were we in the courts to do what we could to ensure that the maximum number of cases could be dealt with, provided they could be dealt with appropriately and safely? And how are we to prioritize the number of cases which could be heard, given that we were no longer able to hear them all? That's a story to which I will return. However, I want to start, as I indicated, with a progress report on access to justice more generally. The perceived barrier which I've identified has in the past been the need, or one of them has been in the past, the need to modernize and reform our court procedures. And the report on civil justice, prepared by a committee chaired by the retired President of the High Court, Mr. Justice Peter Kelly, has recently reported. And I'm very happy to say that the government has accepted its recommendations and has put in place the beginnings of an implementation process. Now, the full rollout of those reforms will take some time and will require a common effort from government through legislation and resources, from the court service through the modernisation of the practical administration of justice, and the judiciary in implementing new court rules, new court procedures. And it'll take some time, I think, for all of the recommendations of that committee to be fully implemented. But I think we have now moved from a stage of planning to an important stage of implementation. And I would hope to see at least some results from that in the relatively near future. Next, I should refer to the Court Service Modernisation Programme, which places a very heavy emphasis on an increased use of IT to ensure the smoother operation of our courts. And I've often commented in the past that the court's IT system suffered particularly heavily with financial cuts during the Great Recession. And I'm happy that the government has accepted the court services plans for modernisation in that regard, and that very significant additional funding, an additional €9 million, was made available in the recent budget to allow for the first year of that modernisation programme to get off the ground. And it'll also take some time for the full benefits of those developments to be fully felt. But I think there should be some early signs of improvement, and that also will undoubtedly contribute to access to justice by making it easier for people to manage their interactions with the court. And while still on the government side, I also welcome the commitment of the current Justice Programme to a review, which I have to say I consider overdue, of our civil legal aid system. The combination, I think, of the implementation of all of these measures, the reform of procedures, the modernisation of the court process, the application of IT, and an increase in civil legal aid should improve things significantly. But there are, I think, still other strands to the solution as well. And in that context, I've recently established a working group in conjunction with the chair of the Legal Aid Board and the Free Legal Advice Centres, the Bar Council and the Law Society, to identify and hopefully implement other ways of improving access to justice. And it's hoped that this working group will organise a conference in the first half of this year with a view both to increasing public focus on the areas that are already in train, which I've mentioned, but also to identify what more can be done and potentially put in place means for implementing such plans as may emerge from that conference. I suspect that issues around access to justice will always be a work in progress, but there is now, at least in my view, work and progress. But the more immediate problem of the day has been to keep our courts open so that people can have access to them. I would therefore like to describe what we have done over the last year, and hopefully I would like to think to demonstrate that the courts have been very agile in responding to a very difficult situation, but also to consider what we've learned from what worked, and perhaps also even more importantly from what didn't work, and what parts of the emergency response may find some useful role in the future of our court system. In that context, as we approach the one-year anniversary since then Taoiseach Leo Varadkar addressed the nation from the steps of Blair House in Washington, D.C., where he announced the closure of educational facilities, amongst other measures, it's opportune to pause and reflect on the journey that the courts have been on during that past year. As an aside, I should say that I and my colleagues on the Supreme Court listened to that address on the radio as we were assembling to hear a case, as it happens, a case called Bank of Ireland v. E-Teams International. It's a striking fact that since that day, which was Thursday, the 12th of March, almost exactly a year ago, the Supreme Court has not sat in the Supreme Courtroom. Since then, the business of the court has moved to a remote setting with all appeal hearings, case management and other procedural issues being conducted on the court's service platform, which is called PEXIM. One appeal in the climate change case was the only case which took place physically, but that took place in King's Inn. And I'd like to outline some of the key responses which we have undertaken since March 2020. The following day, which I suppose ironically was Friday the 13th, saw active discussions between each of the 5 court presidents. As you know, there are 5 tiers to our courts, and each of those tiers has a president, with the Chief Justice being the president of the Supreme Court. And we were joined from time to time by senior managers from the court service. And the purpose was to formulate a coordinated response in the light of the fast evolving situation which the country was then facing. The core decision which was reached that day was that the courts would have to move to a situation where we could only conduct urgent business. Of course, there are many types of court cases, and some just have to be dealt with, cannot not be dealt with. For example, when people are arrested, they must be brought before a court immediately. And as I pointed out at that time, domestic violence doesn't stop just because there's a pandemic or a lockdown. And indeed, much research suggests that issues like domestic violence become more acute in lockdown situations. So there were cases which just had to be heard, but we decided collectively that we would move to a situation where, in the light of the uncertain times, very uncertain times, which prevailed then, to only hearing those cases which really had to be heard. But it was left to each court president, in conjunction with relevant court managers, to decide just how that was going to work in their court. because the kinds of cases and the kind of pressures that arise differ from court to court. That was the immediate response. And like so much of the country, much of the courts had to close down. The response was not perfect. However, I did say at that time that while closing down things was relatively straightforward, opening them up again would not be so easy, and I think that proved to be the case. The initial decision continued to inform the court's work during the first lockdown period, but it was tweaked from time to time, but not to any great extent. One of the earliest attempts that was made to improve matters was to move certain kinds of court hearings to a remote platform. Members of the Supreme Court, like many others, have had to adjust to working remotely in the last year and familiarizing ourselves with video conferencing platforms. Conducting remote hearings from our homes, like where I am now, has become the de facto position for almost all Supreme Court hearings since last April. But to ensure the constitutional requirement that judgment should be administered in public, each remote hearing is available to be viewed in a courtroom. So that, for example, in the Supreme Court, while the court hasn't, as I said, physically sat in our courtroom since the 12th of March last, all of the business of the court that would ordinarily be conducted in public, the hearings other than the hearings in camera, are displayed on large screens in the courtroom with only a registrar present and anyone else who happens to be able to be in the court. And while attendance in court buildings is only encouraged for those with business in the court, members of the public who do attend actually get as good a view as anyone else of the remote proceeding. And in addition, members of the press or interested academics have been allowed access remotely to the remote hearing. So I think we have maintained, as best we can, public access to the hearings of the court. We then moved to May 2020, when the government programme to somewhat reopen society was put in place. We had maintained more or less the urgent cases only model up until then. But from May 2020, we were able to implement plans which we had been developing since the initial large shutdown as to what we would do when it became possible to conduct a wider range of cases. The reopening allowed us to move from a situation where we were only in a position to hear cases which were really must be heard category, or in a must be heard category, to a situation where we decided at the level of principle that we would hear as many cases as could be heard safely and in accordance with the changing level of government regulation and advice from time to time. And that principle was again agreed at a high level by the court presidents in conjunction with senior managers, but it was again left to individual presidents or even judges in charge of particular areas or sections of work to work out how that would work in practice. And there were and there continue to be significant challenges. And I'd like to discuss some of the lessons that have been learned. Firstly, I want to touch on our stock of courtrooms and courthouses. None of them were, of course, designed with a pandemic in mind. And at a very early stage, the court service COVID management team undertook an assessment of every courtroom in the country to determine just how many people could safely be accommodated while complying with the 2-meter rule and all other similar requirements. And indeed, since then, we've managed by moving furniture around a bit to be able to increase the number in some of the courtrooms that could be safely accommodated. However, perhaps what hasn't been as fully realized as might is that the real problem wasn't the courtroom. It's not too hard to do that exercise and determine that you can get 15 people in that courtroom or 22 people in that courtroom. The real problems were the courthouses, which were never designed for the kind of way in which we're trying to operate business at this stage. if you have a very large number of people in a courthouse, even if the courtroom is safely controlled, the danger to transmission is every bit as large. And there may be situations where you could perfectly safely operate, in theory, 4 different courtrooms in a large provincial courthouse, but where having them all operating at the same time would lead to an unacceptable degree of transmission risk in the courthouse outside the courtroom. And therefore, a number of measures had to be adopted to attempt to prevent overcrowding in the courthouse. Not every courtroom could be used because that would overload the courthouse. Staggered hearings had to take place so that not everyone arrived and left at much the same time. And perhaps this has been a less than fully recognized part of the problem. And it's also one of the reasons why I think remote hearings have played a particularly important part in surviving, the court surviving the pandemic, because a remote hearing, in my view, is an extra hearing. You can have a courtroom with only one person in it, which doesn't place any extra burden on the courthouse, and yet a full court hearing is taking place. And indeed, I've been recently told by the President of the High Court that every bit as many hearings are taking place in the High Court. It's just that a very large number of them are taking place on remote platforms. But we also have to do other things. One of the areas that was most difficult was the conduct of jury trials. There are obviously a lot of people involved in a jury trial. There are the 12 members of the jury, the judge, the registrar, the accused, maybe more than one accused, lawyers, together with victims and others. So that the number of people who actually need to be there, as opposed to might just want to be there for a jury trial, is normally a lot larger than for many other types of cases. In fact, it was possible to finish all the jury trials that had started at the time when the first lockdown began, but no new trials were started at that time. But planning was put in place so that in September 2020, we were able to recommence jury trials. It's been a bit on and off since then, depending on the level of restriction that's been in place. But for example, in the Dublin Criminal Courts of Justice, which conducts a very large amount of criminal business every day, for jury trials, we've had to use two courtrooms for each jury trial because no single courtroom could accommodate all of the people who needed to be there. And obviously that halved the number of courtrooms that were available, or the number of trials that could be conducted at the same time. And with that in mind, we've had to look for additional premises so that we could conduct more trials, and have recently taken a lease on Croke Park to conduct jury trials there in the building part, not out on the pitch. And we think we'll be able to have probably 3 further Dublin jury trials going at the same time there. We'll use our own secure premises with cells and the like for those prisoners who are in custody, and use places like Croke Park for those who are on bail. In addition, in many areas outside Dublin, the court service has had to hire things like hotel halls to allow for jury empanelments where the courthouse was not suitable to accommodate the number of people who need to be there on a jury panel, so at the time when the jury is being selected. And what essentially happened was that our managers searched our courtroom allocation to see what courthouses throughout the country had facilities that were capable of running jury trials. And initially there were 11. I think we've been able to increase that by a little bit since then. And then we have to, as it were, reallocate the jury trials, both from the High Court, Central Criminal Court, and also from the Circuit Criminal Court, to where they could be heard. And that meant, unusually, cases in the Circuit Criminal Court not being heard in the county in which the case arose, but being heard in the nearest county that had a facility where we could safely conduct jury trials. And that continues to be the position at the moment when we feel we're able to have jury trials going. At the moment, we're not, because of level 5, and I'll come back to that in a moment. but we have been renting premises, refitting out courtrooms, doing everything we can to ensure the maximum number of jury trials can be heard, not least because there is a great fear of the build-up of an enormous backlog and the fact that some of the people awaiting trial are not on bail, and there are serious constitutional issues about people spending a prolonged period of time in custody pending a trial, so that both the backlog and that lengthy time in custody pending trial are serious issues which have to be addressed. If I return to the overall consequences of all of these measures, I fully understand that there have been a lot of practical difficulties. For example, typically students in the King's Inns or the Law Society, which some of you may well become in years to come, will want to visit courts as part of their respective learning and training to see how courts actually work in practice. And it really hasn't been possible to allow that at this time because almost all of the witness actions are such that the entire allocation of the numbers that are allowed in the courtroom are used up with those who just have to be there. The parties, the lawyers, the judge, the registrar, the witness, the like. Equally, devils, apprentice young barristers, who would normally be able to sit in at witness actions to see how they're run by experienced barristers, find that they most of the time can't gain access to the courtroom precisely because the people who really have to be there have used up the full allocation of space. We're looking for ways to try and deal with those problems, but frankly, it isn't easy. I mean, effectively, the virus doesn't take account of the fact that there's a student of King's Inns or the Law Society wanting to be in and saying, well, that's kind of a nice thing to do, so we lay off infecting those persons. The numbers are the numbers, and there's some people who just have to be in the courtroom. Next, of course, we did have to respond both to the somewhat limited second lockdown and now the more substantial level 5 lockdown, which has been in place since January. And these have led to a further reduction in physical hearings, with many types of witness actions not being able to be conducted, such as personal injury actions, and only the most urgent of those cases can in effect be heard. I also think we are in the middle of attempting to improve the remote hearing system. I have to say I was very mindful at the beginning that there is a potential for a lack of equality in respect of in remote hearings, in respect of individuals who may not have access to adequate IT facilities to enable them to participate. There are a number of very fancy high-tech systems that are available, but they're very expensive. And we've no difficulty with allowing well-resourced parties to use those, provided they're happy to pay for them themselves. But I was very mindful that it would be very dangerous if we created a situation where there was an impression that you could buy access to the court if you could afford a very high-tech system, but you didn't get access to the court if you were on the other side of what's come to be known as the digital divide. So it was necessary for the court service to put in place an adequate free system before we could roll out remote hearings, and to do that at the same time as better resource parties were given the opportunity to provide more elaborate systems. To be honest, the system we have used and are still using is not entirely ideal. It was not bought for the purposes of remote hearings, but for other purposes, such as conferences between staff and some element of remote witness appearances. But it was the one we had, and to get things going quickly, it was the one which we had to roll out at the earliest possible time. And I'm happy to say, I think it is an achievement of the courts system that we're talking about the 12th of March when it all began. There were remote sittings of the courts in the middle or latter part of April. So I think that was a fairly rapid turnaround and something that no one would have anticipated. But we are hoping to further develop that remote system to one which will be better fit for purpose. In addition, we've also developed so-called hybrid hearings, where some of the participants in the case are in a courtroom and others are not. This allows those who may not have access to adequate IT to present their case in person, even if some of the other participants, judges, other parties, lawyers, whatever, may have access online. And we're significantly increasing the number of so-called technology courts, which will facilitate that type of hearing taking place. I'll come shortly to how I see those developments influencing the way our courts operate when the restrictions due to COVID have come to an end. But for the moment, we do remain at a very high level of regulation and restriction, because in line with the government's announcement last week of the continuation of level 5 restrictions until April the 5th of this year, the court service and the judiciary have agreed to continue the current arrangements for the conduct of court business during level 5 restrictions. There have been a number of minor tweaks with the special criminal court, which, as you know, is not a jury court, being able to start up for cases where there's only one accused. It's again the practical things one has to think about. One accused means 2 legal teams, one for the prosecution, one for the defence. A case with 3 or 4 accused triples or quadruples the number of legal representatives and pushes many cases beyond the level where they can be safely conducted, certainly during level 5. We're due to review that situation again on March the 15th, taking into account whatever the state of government and public health advice is at that stage, and looking at the numbers, and also having regard to the lead-in time you need to get cases up and running again, with parties, and in the case of jury trials, jurors having to be notified well in advance. For example, the criminal trials, which were due to take place in the central and the circuit courts in March, are not now going to take place, subject to that review, on the 15th of March. And the courts continue to give, even in this even more restricted period, priority to those kind of cases I identified earlier, including domestic violence cases. At the launch of the Court Service Annual Report last July, I made the remark that the courts had perhaps moved more in the last 5 months up to July than they had normally done in any 5-year period, responding, of course, to the pandemic. The court service is essential to the administration of justice, and closure was clearly not something that could be contemplated. And while there was a significant curtailing of court hearings, this was done, as I've said, to reduce footfall, because, as has been frequently highlighted, that's the reason for introducing restrictions on mobility of persons generally, and we have to be as much part of that as anyone else. But I suppose the real question for the future, and on access to justice in the future, is what have we learned from our response to the pandemic, and what of what we have learned will feed into the modernisation process, which I see as a key element of improving access to justice. Firstly, I think we did do a lot of things more quickly than we would have done in normal times. I think we've now a better understanding of what works and what might work with a tweak or two, or what doesn't work. And I think that learning will inform a lot of the implementation of the new modernised practices and procedures which we have in mind. My own assessment, others may have different views on this, is that the rapid developments which have taken place because of COVID will lead to a permanent and significantly increased use of technology in the court process. Documents will increasingly be filed in digital form, and the mountains of paper that routinely you see around court will hopefully diminish, and diminish reasonably quickly over time. I might just give one example of how our IT systems create a large amount of unnecessary work. Many of you may be familiar with the Garda pulse system records many things that the Gardaí are interested in, including people who are to be summoned to come to court for a whole range of offences, from traffic offences to whatever. What happens at the moment is when a member of An Garda Síochána wants to prosecute the latest batch of speeding drivers or whatever, that Garda has to print out from the Garda pool system a pile of documents, bring those documents physically to a court office, where all of the same information that is on those documents gets fed by a court official into the court service website, court service IT system. The information doesn't change. The problem is that the two computer systems can't talk to each other. And yet a huge amount of hours of Garda work and court service officials' work is spent doing that process that adds nothing to the system. That's just a simple example, which probably doesn't greatly increase access to justice, but equivalence in the civil justice system, which will make it easier for people to file documents, to understand what's going on, to find out what stage their case is at, what they have to do next, I think would be a significant contributor to access to justice. I also believe that a fair amount of routine courtroom administration will continue to take place remotely. The need for a lawyer to travel to a courtroom for a short 3 or 5 minute hearing about case management seems like a waste of time and something that could just as easily be done with the judge sitting either in the judge's chambers or at home and the lawyer staying in that lawyer's office. That being said, I think there will nonetheless be a significant return to physical hearings for important matters. The view of my colleagues on the Supreme Court, which I share, is that the remote platform for the conduct of full appeals is adequate, but not ideal. And I think the intention would be that we would return to physical hearings for certainly the vast majority of cases when and if it becomes safe to do so. The precise extent to which remote hearings will continue in other types at other levels of the court system and for other types of cases is something on which it's only possible to speculate. Again, I suspect procedural matters such as case management, court motions and the like may well be dealt with remotely to a greater or lesser extent. And there may be certain types of cases where the parties and judges feel that they can be perfectly well dealt with remotely, and where that may allow us to free up space in courthouses, which is a limited resource, for those hearings which really have to be conducted physically, or are at least much better conducted physically than remotely. So I think it's fair to say that the jury is still out on the precise percentage of the business of the courts which will return to physical hearings when that becomes possible. However, I think it's fair to say that the COVID crisis has significantly accelerated other developments which are likely to remain a permanent feature of our system. For example, the Supreme Court have been thinking for some time in the past of developing a new practice whereby a document, which we call a statement of case, is circulated to the parties after they filed their written submissions, but before the oral hearing. The intent was that such a document would set out the court's views on what the questions were without giving an indication of any preliminary view of the answers. And would almost be like if you've read Supreme Court judgments, the first half of the judgment really doesn't give you any answers. It says what the basic facts are. It says what was decided by the High Court and the Court of Appeal, how the parties argued that those courts were either right or wrong, and how the issues therefore are the following. And it's a document that almost looks like the first half of the judgment. So it does two useful things. I think it clarifies everyone's mind in advance of the oral hearing. And if the court has got it wrong about some aspect of it, that can be clarified in advance. And also on a more mundane level, it kind of makes writing the judgment easier and quick, because the laborious bit of recording all those facts is set out in advance. And we were able to implement this because of the sort of a gap at the early stage of the first lockdown, which gave us a bit of space to be able to read the papers in well in advance and begin to send out the statements of case. I think that's an example of a procedure that we were able to introduce in the context of COVID, and which was particularly important because of COVID in the Supreme Court context, because the easy interaction between lawyers and judges that you would have seen when the Supreme Court sat in Galway, if those of you were there, is not at all as easily replicated on a remote platform. And therefore we needed that greater sort of narrowing of focus for remote hearings. But I think that will survive into the future. I posed a question at a very early stage of the process in a video message to court service staff, which was to ask, when the pandemic is over, frankly, it lasted longer than even I thought, and I was on the pessimistic end of those that thought it might last until October last March. Would we think we got everything right? And I said that I thought the answer was almost certainly no. We had to make decisions quickly. As I put it previously, the virus wasn't going to wait for the result of the working group or the implementation body or committee to work out a very considered way of changing things. We were going to have to do the best we could and make decisions often in hours or days, which would normally be made in weeks or months or even sometimes in years. But I think we have done reasonably well. We've also made mistakes, but I would also like to think we have and will continue to learn from those mistakes. Because I think the lessons learned, either in getting it right and maybe even more importantly, getting it wrong, will greatly inform the way in which we implement those many strands of improving access to justice in the future. The increased use of IT and how it can best be deployed and where it can best be deployed. The modernization of our procedures. Each of those will, I think, be able to be implemented quicker and better because of what we have had to learn quickly ourselves during the pandemic. So I think those strands are afoot. I think we are about to see an improvement in access to justice, but the proof of the pudding will be in the eating, and we are only now beginning what I've called an implementation phase, having been involved in a planning phase up to now. I'd like to think that that outline of how we've responded to the challenge of COVID and have managed to maintain a reasonable level of access to courts during that time, despite those challenges, may be of some interest. The changes that will come about will, in my view, be significant and many of them permanent. That will bring challenges. But can I suggest to the students of NUI Galway that it also brings opportunities for those about to embark on a legal career? The advantage of long experience can often be very useful in many fields, and not least in the law. But where the ways of doing business change, the advantage of long experience diminishes, and there are therefore greater opportunities for those who don't have to unlearn the old ways, but can immediately exploit the new. I truly believe that the way in which our courts will operate will be significantly different in 5 years' time to the way it was on, say, the 1st of January of last year before the pandemic struck. And those who are able to most easily operate in that new world and who don't have to unlearn old ways that will no longer be applied will, in my view, have significant advantages. And in that context, before finishing, I'd like to draw attention to one specific program that may give those participating an even greater insight into how our courts are now operating, particularly in these challenging times, but also may operate in the future. I'm pleased to announce that the Chief Justice's Summer Placement Programme will again take place later this year, and that your School of Law will shortly receive further information and an invitation to nominate 2 students from the School of Law at NUI Galway to participate in this year's programme. It would be necessary for obvious reasons to conduct the programme remotely, but we did that last year, and I think it was adjudged a success, notwithstanding missing out on some of the things that would have happened when people were physically around the court. But there will be an extensive schedule of lectures, talks, remote court visits, ability to consult with individual judges, and they will be in place for all of the participating students. And I very much look forward to meeting, if only remotely, the nominated students from NUI Galway, along with the students from the other participating institutions when the programme commences later this summer. I know that the former Associate Justice of the United States Supreme Court, Ruth Bader Ginsburg, addressed this society in 2007. She was a champion not just for human rights, but for feminism and the importance of the rule of law in a democratic society. And in one sense, building on the initial words of the auditor at the very beginning of this session, I might quote an address she made at Stanford University in 2017, offering advice to students, which I would echo. If you're going to be a lawyer and just practice your profession, well, you have a skill, much like a plumber. But if you want to be a true professional, you'll do something outside yourself, something to repair tears in your community, something to make life a little better for people less fortunate than you. That's what I think a meaningful life is. One lives not just for oneself, but for one's community. Can I conclude by thanking the auditor and the committee of the Law Society for inviting me to address you at the start of what I know is a week-long series of exceptional events to mark the centenary of the NUI Galway Law Society, and to congratulate the Society on its longevity and wish it even greater longevity for a further century. Thank you very much.
Great, thank you very much, Chief Justice. That really was a wonderful talk, and it's very heartening to hear you speak to the progress that you have made on court reform. And as you mentioned, you spoke to this topic at the very start of your term as Chief Justice when you visited Galway in January 2018 and spoke to that topic. And it's fantastic really to hear about moving into this implementation phase for the recommendations for reform of administration to justice and removing some of those barriers around access to justice. And I think really that's no small part due to your proactive and collaborative approach to grappling with these issues. So you've covered quite a lot of ground really in that talk, ranging from the reform of key issues in accessing justice and also in terms of the lessons learned around crisis planning during the pandemic. We actually have quite a lot of questions, so I'll just kind of go to those questions now. Some of them might get you into a little bit of hot water if you were to answer them. You would end up on the front page of the Irish Times, so feel free to decline to answer or give no comment if it is going to get you into a bit of hot water. So I'll start with this question, which I don't think will get you into hot water. Just one student is seeking your view about whether posting video summaries of Supreme Court judgments online in the same way that happens in the UK Supreme Court would promote greater awareness of the role of the Supreme Court and the important issues that they address.
Yeah, as you may know, one of the innovations which I brought about was to allow RTE to film the delivery of judgments. Now, one of the consequences of the pandemic is we're no longer giving judgments verbally, they're just posted online, but we may well go back to a synopsis of the judgment being given in court. I think it would be a good idea. We are considering a number of measures. The current court service, Supreme Court website is pretty antiquated. It's subject to a great review at the moment. And one of the things we're giving serious consideration to is something exactly along those lines, that we would have on our website a synopsis of each judgment as it was being delivered. And I think that would increase access to justice. I think the more people can see what goes on, the better we all are, because actually I think most of what goes on is quite good. And sometimes people's bad impressions of the court are due to people not understanding it, but sometimes it's our fault for not letting them understand it properly.
Great, thank you, Chief Justice. The next question I have here is a question around the impact of the pandemic on newly qualified barristers and whether newly qualified barristers are having effectively their careers paused because they cannot physically be present in courts. And this is a very crucial phase, a formative phase in their legal career.
I think probably the honest answer to that is yes, it is having an effect. I wouldn't like to be a young barrister starting my career this year. It's also disrupted work. And I think the kind of cases that young barristers often get are cases which have been differentially affected. If you're the kind of top senior counsel who's often in the Supreme Court, well, we've heard as many cases in the pandemic year as we would ever hear. So it hasn't affected their business. But younger barristers who might go out to a remote district court for a couple of minor things as partly learning their trade, but also begin to earn a little money, are probably finding themselves more impacted. So hopefully, for those who haven't yet qualified, they may be able to benefit by the fact that that will come to an end, hopefully by beginning of at least the second next legal year, and the kind of opportunities that I identified might then begin to come into play instead of the disadvantages. But it would be naive to think it hasn't had a bad effect on those who were unlucky enough to come into practice at the wrong time.
Great. Next question is around your view on a greater role for bodies such as the Injuries Board as a way of freeing up more court time, presumably to facilitate greater access to justice. Your views on kind of bodies such as that?
I don't have any strong view on the extent to which bodies outside the courts can do things that reduce the need for people to go to court. I remember making a comment a couple of years ago when I was invited to speak at the launch of the annual report of the Press Council, that I felt the form of redress which someone can have who doesn't want to bring a big court action and sue for damages, who just wants a recognition of the fact that something wrong was said about them in a newspaper and an apology, that a body like that can do very useful work by taking cases that don't really have to go to court out of court. And I think plenty of bodies like that can. I think court should be there for things that have to be in court, not for things that are in court because there isn't a better way of dealing with them. For example, leaving aside altogether, bodies such as that, mediation, for example, can remove from the courts cases which don't really need to be heard, but which can be resolved sometimes in a better way than it can ever do it by a mediation process. So sure, I'd be in favor of anything that removes unnecessary litigation from the courts.
Great. The next is maybe one of those questions that might get you into a bit of hot water. The student is seeking your view on the Special Criminal Court. Do you think that the Special Criminal Court is necessary today? And would you agree with the UN and Amnesty International, who would view the Special Criminal Court as impinging upon? I
think that is the kind of case that a sitting judge should decline to answer. But I do note that there has just been established a review of the Special Criminal Court. So perhaps the cowardly thing for me to say is I'll wait and see what that review comes up with.
You will be making the front page of the Irish Times, so tomorrow.
I think I've had enough of the front page of the Irish Times in recent times.
Great. The next question is about whether the courts and the court service are really ready to embrace a more IT-focused approach to the administration of justice.
I think they are. The fact that a lot was done in 1 year, I think, but perhaps I should go back a step. The Court Service Modernisation Programme was passed by the board of the Court Service actually just before the pandemic struck in the latter part of 2019. So the plan for the future was there. I think elements of it have had to be accelerated because of the pandemic. But we have been employing a large number of additional IT experts. It hasn't really manifested itself publicly yet because we were coming from such a low base. It's taken longer than I thought it would and longer than I wanted it to get to the stage where we could actually begin to implement things. But I do think there's a real appetite. And the fact that, if we were sitting here 13 months ago, and we were talking about there being 20 High Court judges every day hearing a case on a remote platform, I think we would have all thought we should pay a quick visit to a doctor. And yet it's happened. So I think that is at least a bit of the pudding that has been eaten and has been shown to be tasty. So I think there is an appetite. both among judges and among court service staff to go that way. I think it'll take a bit of time to have the platforms in place, to train people, to get people used to using them. But I think it will happen, and probably happen a bit quicker than we might originally thought.
The next question is in relation to a trial in due course of law and whether the pandemic has resulted in delays with criminal prosecutions and whether that is affecting defendants' constitutional rights to a timely trial.
Yeah, I need to be careful because these are issues which could actually come before the courts. I mean, as I indicated in the main part of my speech, there are now increasing delays in cases coming to hearing. Obviously, that's most acute for those who are in custody, who have an added layer of right potentially infringed. But I think it would potentially, if it's not solved reasonably quickly, lead to issues at least being raised as to whether people were entitled to a timely trial. I think it's also important to emphasize that it can have a very deleterious effect on others involved in the process. A victim of crime who is anticipating a trial may suffer unduly the longer it is before that trial comes on, particularly more sensitive kind of trials such as sexual offences. So making those people wait longer is not a good idea either. And that was why we put a very strong case to government that we needed additional funding to be able to go out and rent premises, because if we hadn't rented premises, backlog would be even longer. And if it weren't for level 5, we would probably have been conducting about 90% of the criminal trials that we would normally be conducting. Level 5 has kind of put the kibosh on that. But it perhaps does raise an important question. Even assuming we have an adequate number of judges at the High Court and Circuit Court level to deal with sort of the current number of criminal trials that are being commenced, that won't affect the backlog. Whatever backlog builds up will remain in place unless we have additional resources to clear the backlog. If we could handle whatever it might be, 2,000 cases a year with the current number of judges, and even if we get back to being able to do that 2,000, that won't eat into whatever backlog has grown up. So I think what's going to come into focus in the very near future is the need for additional resources to clear the backlog, even if those resources mightn't be permanently needed in 10 years' time when the backlog is cleared to deal with ordinary business. So there may be need to consider appointing extra judges, even if retiring judges may not be all replaced in 5 years' time, so that we have extra judges in the short term to handle backlogs for the very kind of issues that the questioner has identified.
Great, thank you, Chief Justice. There's a couple of questions. I'll probably just group them into one question around legal aid, and obviously noting that access to justice is much broader than legal aid. But the limitation on accessing legal aid in important cases such as housing, homelessness, in relation to employment or anti-discrimination, breaches of that discrimination laws, the Equal Status Act and the Employment Equality Acts, that really limits access to justice in Ireland. How can this be overcome? Is the question really that has been posed by the students.
Better legal aid. I think I think there are two elements to legal aid which need to be looked at, and as they say, I've welcomed the fact that the government is now looking at it. One is scope, which I think you've just outlined, the kind of cases for which legal aid is available, and secondly, the thresholds for qualifying for legal aid are very low. There's plenty of people who would be above those thresholds who would find it very difficult to finance even relatively modest litigation. So I think both of those elements do need to be looked at. I think there's an interesting, I described it once at a FLAC conference as an elephant in the room, which is the entitlement in the EU Charter to legal aid for any case in which EU rights are involved. Now, that won't cover all areas, but where it's considered necessary for there to be an effective remedy. In other words, it's the kind of case that someone couldn't reasonably be expected to do themselves. And I've often commented that I think one of the big differences between the civil law countries and the common law countries is that a much greater part of the burden of running litigation is placed on the parties in a common law country. You have much greater control over what happens, but you also have to deliver. And therefore, there are probably more cases in a common law system that a person couldn't reasonably run themselves without legal assistance. And I suspect someday there's going to be a case where someone says, this case involves rights which I enjoy under European law. The Charter says that I'm entitled to legal aid if that's necessary to vindicate my rights. And having regard to the nature of this case, it's not a case which I could reasonably be expected to do without a lawyer. That might be a backdoor also into a more expanded scope of legal aid and perhaps higher thresholds as well.
Great, thank you, Chief Justice. The next question is whether you're worried that in a post-pandemic Ireland, we're going to see the same impact on access to justice that we saw at the tail end of the last recession, where really we saw cuts to public expenditure, which disproportionately impacted access to justice and the administration of justice in this jurisdiction.
It's always a concern. Part of the reason why the court service set out such a long-term plan for the modernisation programme was we wanted, I mean, you'll never get government real commitment for a 5-year programme, but there's little point in paying for the foundations if you don't pay for the structure. And we felt that if we put forward that plan and said, these are the foundations, they're not very much use of themselves, but if you pay for them, we will then be able to build the structure. And, you know, I think it will give us a reasonable case to make if you do find reductions in government expenditure, that it would be a waste of money to build the foundations if you're not prepared to put more money into the structure. But there's no guarantee that funding will be available in 5 years' time. And also the legal aid issue we've just spoken of is clearly a funding issue. You know? If I might explain why I think things went, particularly on the IT front, so badly in the recession, where some things are easier to cut than others. You know, okay, we can cut wages as did happen in the recession, but it's harder to get rid of staff, particularly in the public sector, so that your staff bill is kind of fixed. And if your staff, as in our case, is more than 50% of the total expenditure, if you have a 10% cut in your budget and you can't cut the staff side, the other side has to be cut 20%. And some things are kind of constant, like rental on buildings and the like. So, you know, it was, I think what happened was IT was easy to cut because there wasn't long-term commitments to a lot of it and it got cut. But I think perhaps a lesson has been learned from that it actually was counterproductive in the long run and cost more money in other ways because it had been cut so radically.
Great. I have a couple of more personal or easier questions that some of the students posed, which I will now ask you. One question is, if you were to give one piece of advice to an undergraduate law student, what would that be?
Be ambitious, I think. I don't mean in the sort of ruling the world sense, but if your inclination is to, I mean, there are so many ways in which you can practice law in a loose sense nowadays. There's obviously the traditional practicing professions of barrister and solicitor. There's academic life. There are many NGOs now have legal advisors. There's work in government. There's work in research now, such as the Law Reform Commission. The court service itself now has a significant research department. So there are many different ways in which you can use your legal skills. But I would be inclined to advise to go for the one that you would most like to do. I think if you're happy doing something, you'll be good at it. And I'd rather try to do whatever bit of it you would most like to do, And okay, if it doesn't work, well, then you might have to do something else. But don't be conservative about thinking, oh, that mightn't work for me, I shouldn't do it. And what might work for different people will be different. Some people like the idea of standing up in court, arguing cases. Some would run a mile from having to do that and would think it would make them get sick every morning. So, there's different strokes for different folks, but I would pick the stroke that you think suits you and go for it.
That's very good advice indeed. Thank you, Chief Justice. A lot of students are commenting on your lovely library behind you as your backdrop, and they would like you to recommend one book about the law and that you would recommend for them to read.
I think for an inspiring book, The Recent Life of Ruth Bader Ginsburg would be a great book to read. It gives you gives a reason for wanting to practice law, and I think there's millions of books on what the law is, but a book about why you might want to be a lawyer perhaps is something that a student should really read.
The next question is about your own legal career, and was there a particular point where you thought, yes, I want to be a judge?
There wasn't a sort of blinding moment where I suddenly woke up one morning and said, yeah. I mean, I suppose one of the things I always liked about the career as a barrister is you can kind of reinvent yourself as you go through life. You start as a junior counsel. If you're lucky enough, you may get to be a senior counsel, and that's a very different role. You're now the sort of leader in big cases rather than doing routine cases or being a junior member of a team in big cases. So that is one reinvention. And indeed, having become a judge, you can then become an appellate judge, which is a different game again from being a trial judge. But I suppose, maybe you get stale if you do exactly the same thing for too long. And I was lucky enough to become senior counsel very young. I was only 33. So when I was kind of late 40s, I'd already been a senior counsel for more than 15 years. I'd done a fair amount of fairly major cases. And I think I realized the time had come that I wanted to apply the same skills, but in a slightly different way and not get stale. So I'd say sometime in the middle of my career as a senior counsel, I began to think that maybe, I'd like to be a judge at the end of this and before I'm too old to make a useful contribution.
Another question that was posed was if you had not only the judicial power, but the executive and the legislative power, what is the one thing you would change in the morning to facilitate greater access to justice?
Well, I think I would use the power to greatly expand the availability of legal aid in Ireland. I think it wouldn't solve all the problems, and it wouldn't solve the problems without being in conjunction with the other reforms, because if your procedures are too complicated, then whoever's paying for them, it's going to cost more. A legal aid budget will go further if you have more streamlined procedures. But I think the single thing will make the biggest difference will be that.
Another question that came up here a couple of times was about your views about the unification of the solicitor and barrister professions.
Personally, I don't think it would add to the effective running of our courts. I have a number of reasons for that. Firstly, it's interesting that if you look to some jurisdictions where they were legally amalgamated, New Zealand being one, 4 of the 6 provinces or territories of Australia being others, in fact, an independent referral bar, a bit like the one that exists in Ireland, grew up on an ad hoc basis because there was a need for it. And I think it does a number of things, one of which is at least relevant to access to justice. I've no doubt that if you had a unified profession, almost all of the top trial lawyers, as they then would become, would live in big firms. And the ability to access them if you go to your local lawyer in a small provincial town would, I think, be diminished. I remember when I was chair of the Bar Council 25 odd years ago, I made the point that at that time there were 3 or 4 very big cases that were very well known. None of your students, I suspect, would remember them because they all happened before they were born. But there were cases in which a small man or woman against the big battalions. One was done on Holles Street, for example. O'Hanlon and Merck Sharp and Dome was another. And I went through the lawyers who'd represented the small parties in all of those cases. And there were people like Dermot Gleeson, absolutely #1 barrister around at the time, afterwards Attorney General and the like. Fred Morris, who was the leading personal injury barrister of the time, appeared in some others of them, subsequently president of the High Court. And I did comment that that system that allowed a relatively small solicitors firm in provincial Ireland to have the services in court of a Dermot Gleeson or a Fred Morris was a system I wouldn't likely change unless I'd some guarantee that in 10 years' time, the next generation of the Dermot Gleesons and the Fred Morrises weren't going to be partners in, I don't know, A&L Goodbody are very kind to NUI Galway, and I'm sure they do their fair share of pro bono work as well. But if all of the top trial lawyers were in the big 5 or 6 firms, then I don't think that would enhance access to justice because it might impair equality of arms. So for those 2 reasons, I don't actually think it would improve things, and I think it might actually disimprove things.
Great, thank you. Another question, you've kind of touched on this already, is about really getting more in-depth reporting by the media in relation to cases. You've spoken to inviting RTE into the courtroom. Are there other ways in which you can see that be more effective?
It's a difficult task because I actually think the professional court reporters, the court correspondents of the major media outlets are very good. And it can be a very difficult task, I think, particularly in the broadcast end of things, where you're given, if it's a really important case, you might get 90 seconds. Most of the time, you might get 60 seconds. And you're trying to convey what happened over 4 or 5 hours in a courtroom. And that is not easy. The print media obviously gets a bit more leeway in that the article can cover a bit more of the hearing. Maybe, I think there's some elements that perhaps we haven't been so good at. I think we need perhaps to have synopsises of judgments ourselves to give out more often to explain what it's about, rather than have someone on the hoof trying to read a 40-page judgment and give a coherent synopsis of it. I also think we need to be more proactive in explaining what goes on in courts outside. For instance, one of the more recent innovations is a pilot program that just finished, and we're now going to set it up on a permanent basis. It's called CORA. And CORA was a means whereby students from a secondary school, typically from transition year upwards, were given an opportunity to meet remotely with 2 judges as a Supreme Court. Sorry, this was done remotely even before COVID. It was so that the school didn't all have to come to Dublin. They could sit in the school hall, ask questions of judges. And I think that kind of outreach that allows people to understand better what's going on in the courts is an important part. And it's another sense of access to justice, that people can access what is happening in the justice system. So I'm very much in favour of expanding those, and we're now putting that CORA on a permanent basis. And we probably get to do 8 or 10 schools every year, selected by the National Association of Principals and Deputy Principals.
I have a really interesting question here on equality, diversity and inclusion within the legal profession, and your views on creating a more supportive environment for non-Irish lawyers to join the legal profession and also to ascend to the ranks of the judiciary. Your thoughts on how we can achieve that better?
I think the starting point has to be to get people to the point where they think about it. It's easy for those who grow up in a certain background where perhaps filling roles in the professions or the like would be what happens to them and their friends and their parents and whatever. I think we need to have an outreach to those communities. I think it'll take time. I mean, there's the beginnings. There have been quite a few barristers qualified over the last couple of years. I get at least to some extent to meet everyone because they're physically called to the bar in the Supreme Court. And it is interesting that one of the jobs that some of my staff have to do is to check the list for pronunciations, because I think the least thing the Chief Justice could do is get the person's name pronounced correctly. And I've noticed in recent calls to the bar that there's probably a lot more that I have to get some assistance on precisely how you pronounce the name, because the person doesn't come from what we might call a traditional Irish background, whether Os Béarla or Os Gaeilge. So it's beginning, but and I absolutely agree that it is essential if we're to have a more diverse judiciary. I think that'll take time. I mean, the idea of the non-traditional Irish is something that's probably only 15 to 20 years old now. There aren't too many people who would have had the chance to go up through the ranks, as it were, and get to the judicial stage. But I think programs such as the one the Bar Council developed called the Denham Fellowship, that encourages people from non-traditional legal backgrounds to and gives help to them. I also think the bar probably has to deal with some issues. The traditional model of the unsupported sole trader is not ideal for those who don't have resources behind them. So I think devising ways that give more support to people in the early stages of their career. So I'd see sort of two main things. One is an outreach to non-traditional Irish communities to identify, to encourage involvement in the law. And there have been some very good groups of young lawyers involved in that kind of activity, but maybe it needs to be put on a more formalized basis. And then secondly, supports when people are in university or in the early stages of their career to ensure that we don't have a disproportionate dropout. I think if you do that, then the judicial end will solve itself in time, because a reasonable proportion of those who will get to the stage of being experienced enough to be appointed to the judiciary will come from a range of different backgrounds. And we saw that to an extent with the position of women. The day I joined the law library, there were about 275 barristers, of whom 8 were women. It took some time for there to be a cohort of women who had been in practice long enough they would qualify to be judges. But we now have a situation where I think it's 37% of the entire judiciary are women, and it's moving up all the time. If you leave aside those who were appointed kind of more than 15 years ago, the High Court is nearly 50-50. The Court of Appeal is close to 50-50. The Supreme Court has varied between 5-4 and 6-3. So the senior judiciary is now relatively evenly matched between men and women. But it took time to get there because you needed to have people who qualified. And there was a significant increase in the number of women who began to qualify as lawyers in, say, the late 70s, 1980s. But you're probably getting into the noughties before they were around long enough that they could be appointed in those numbers. And I'd like to see something similar happening with other areas of diversity.
I'm kind of conscious of it over time, but a number of questions I'll probably group, if I can try and group them together, are around the points you spoke to around remote working and whether that is having an impact on the dynamics in terms of, let's say, cross-examination or evidence, or whether that is something that is, I suppose, impacting the rights of accused persons, or it is a real challenge for judges to manage remotely. So just those, I suppose, unintended consequences from having to work remotely.
Okay, well, firstly, we haven't run any criminal trials remotely.
Mm-hmm.
So the idea of the accused person being affected by it just hasn't arisen. The other side of that coin is we're having the delays in trials because we're not conducting them remotely that led to the other problems that were identified in earlier questions. And we have, to a large extent, not had too many witness actions run remotely. But perhaps isn't always understood until people have a bit of practical experience, is that there are all sorts of categories of cases that don't have witnesses at all, where all of the evidence is given on affidavit in writing. For example, almost all judicial review cases, cases involving European arrest warrants, most environmental cases are judicial review. So there's, particularly at the High Court level, there's a very large amount of the work doesn't involve witnesses, but very few witness actions have run remotely. And I think the reason is the very presupposition of the question, that there is a concern that the ability to assess evidence and effectively cross-examine isn't quite so good remotely. I think perhaps on some of the very high-tech systems that are very efficient, it's not so bad, and commercial parties seem to be happy enough to do it. But there is an effect, I think, even on the dynamic of those cases that don't have witnesses. The sort of interaction between the court and counsel is altered. I mean, you just can't do things in the same way. For example, body language, which is obvious in a courtroom, may not be at all as obvious if you're trying to peer into the quarter screen or the 1/9 of the screen that's available. And that's why I actually think I've described it as adequate, but not ideal. And my reason for using that language is I think it being adequate means it's better than not doing the case at all. And for the reasons I tried to explain, I think every remote hearing is an extra hearing, because it's a hearing that isn't taking up a courtroom for the kind of cases that have to be heard physically. So in most cases, it's a choice between a remote hearing and not having any hearing at all. And if the hearing is adequate, I think that's fine. But if it's in those types of cases where it's not adequate, then I think we have to live with not having the hearing at all. But it also means that at least a reasonable chunk of them, in my view, will go back to being heard physically when that becomes safe.
Great. Thank you very much, Chief Justice. I'll hand you back to the Auditor, Niamh. And just to say thank you really for a fantastic and stimulating talk. There was quite a lot of comments in the chat about how inspiring and how positive your talk was and how informative it was. So thank you on behalf of the students in the audience for a really stimulating talk. Thank you.
Thank you for having me. And I hope that we may be able to have a physical event sometime in the future down in NUIG again. Thanks.
Thank you, Chief Justice.
Thank you, everyone, for joining us for this first event of the NUI Galway Law Society Centenary Celebrations. I would like to once again thank our sponsors, A&L Goodbody and NUI Galway School of Law, and to express our deep gratitude to the Chief Justice for joining us here today. It has been truly insightful and an absolute honour to have you here to mark the beginning of our celebrations. So thank you. Last but by no means least, I would like to acknowledge our Vice Auditor, Patrick McWalter, and all of my colleagues here at LawSoc for their continued determination and support. And just to thank everyone for joining us here today. And we look forward to continuing our celebrations with you throughout the week. We're delighted to say that you can find more information about our centenary celebrations, including our event to mark International Women's Day, on our website, which is NUIG Law Society at wordpress.com, and we'll have that mentioned in the chat function now. So thank you all so much for joining us, and yeah, we'll see you at our next event.